And the man who argued the case in front of the Supreme Court, Paul Clement, former Solicitor General of the United States, joins us now to share his insights on this big win. Paul, what does the Kennedy decision say about the importance of a diversity of voices in American society?
Well, Montse, it's great to be with you. And the Kennedy decision makes clear that among the diversity of voices that people can hear in the public square, that religious voices and prayer can be part of that discussion. And school districts and governments do not need to bend over backwards to try to limit the voices, the secular voices, but can extend the kind of full range of voices to people who want to speak from a religious viewpoint or want to engage in prayer.
That's right. In America, we have freedom of religion, not freedom from religion. Why was it so important to protect this coach's personal prayer in a public space?
It was so important because it was so important to Coach Kennedy. I mean, Coach Kennedy is really the hero in this case because he was willing to stand on principle. He was willing to fight all the way to the Supreme Court in order to engage in a religious practice that he felt compelled to engage in. This is, I think, sometimes hard for people who approach these issues from a more secular standpoint to understand. But when somebody like Coach Kennedy decides that it's important to his religious life and his prayer life to engage in a brief prayer of thanks after the football game, it's not optional for him. He feels called to do it. And so he was forced to choose between continuing in his job and following that call. And I think in order to vindicate his rights to follow that call, that was why this is just such an important case for religious liberty.
And in vindicating those rights, the court had to do something really important. This term, the Supreme Court clarified that allowing religion in the public square doesn't mean that the government is endorsing or establishing a religion. Can you explain that to us?
I'll try. It's super important because the reason that these cases with, student speech or teacher prayer or coach prayer keep coming up is that traditionally schools and other government offices have felt like they're caught between a rock and a hard place. Mm-hmm. They feel like if they deny somebody their right to engage in religious exercise, they might get sued. But if they allow it, they'll be sued by the ACLU or Citizens United for separation of church and state because they've endorsed religion or they violated the Establishment Clause. And what's so important about the Kennedy decision is the Supreme Court has made even more clear than it ever has before that school districts don't have to fear liability if they simply allow private religious speech to take place on the school grounds. To paraphrase the court, the school doesn't endorse everything that it fails to censor. It can allow Coach Kennedy to engage in his own personal private prayer, and that doesn't become the school's own prayer.
That's right. They don't have to own everything that people say. Otherwise, we'd be in really big trouble in this country. Well, let's talk about the other cases that you argued before the court. I think people forget that you're a known quantity at the Supreme Court, and you argued 4 cases this term, one of which that you won on concealed carry here out of New York. And the same day, your law firm gave you the impossible choice of choosing between your job and your clients. Tell us what happened.
Well, thank you, Montse. I mean, obviously, the Supreme Court decision was a big win for my clients, who included 2 individual New Yorkers who had their constitutional rights vindicated by the Supreme Court 6-3. As you indicated, the law firm then essentially gave me, as you say, an impossible choice to either drop those clients, including the clients that had just won in the Supreme Court, or leave the law firm. And although in some respects it was an impossible choice, in other respects it was just a very straightforward choice. Because for a lawyer, your relationship with your clients is a special relationship. It is a real calling, in a sense, professionally, to represent those individuals and carry through the representation till the end. You have a lot of choice as a lawyer as to which cases you take, but once you take a case, your obligation is to follow it through to the end unless the client has breach their duties to you. So I really felt in the end, the choice before me was a clear one. And so my partner, Aaron Murphy, and I stuck with our clients and have left the firm.
Let's wrap up the Supreme Court term this year. What was the main message from the Supreme Court on religion and religious liberty?
Well, the main message is that religious liberty is protected very robustly in our Constitution. Our Constitution isn't neutral on the question of religious liberty. It's very protective of religious liberty. And you saw that both in terms of kind of free exercise cases, but also in terms of what the court said in the Kennedy case about the Establishment Clause. For a long time, the court had applied a test, the so-called Lemon test, that was really very begrudging in terms of religious liberty and made it very easy for the government to be accused of violating the Establishment Clause. And the court, by a 6-3 majority, made clear that that really has no role to play, and the Constitution and its religion clauses work together to protect religious liberty.
That's right. Religion has a special place in American society, and we are allowed to be first-class citizens and to bring it with us wherever we go, rather than pretending to be second-class citizens because we believe in one God. This is a historic term, and one that we'll be looking forward to talking to you about in the future as things unfold next Supreme Court term. Thank you so much, Paul.
Great to be with you.